In 2024, the High Court of Australia delivered a decision that mapped the exact boundaries of employer liability. The facts of the case center on a single employee subjected to a formal disciplinary investigation by his employer. The process was poorly executed, and the employee subsequently suffered a severe, documented psychiatric injury. During the proceedings, the employer made a critical concession. They admitted they had failed to follow the steps explicitly laid out in their own company disciplinary procedure. They had definitively breached their own documented process. Based on that breach, the employee launched a multi-million-dollar damages claim. Crucially, this claim was levied against the employer specifically to demand compensation for the psychiatric harm caused by the flawed investigation. This specific sequence of events forces the legal system to confront a difficult question. The court must decide if a procedural error in a human resources department equates to full financial liability for an employee's subsequent mental health crisis. To understand the court's approach, we have to isolate the specific domain of law being debated. This is a case about contractual damages. It deliberately sidelines workers' compensation claims and torts. A tort is a civil wrong, such as negligence, where the law imposes a duty of care outside of any formal agreement. This case relies entirely on the mechanics of contract law. In this context, a breach of contract occurs because the company's internal policy manual was drafted in a way that made it a legally binding term of the employee's contract. By violating the HR manual, the employer violated the contract itself. The central legal tension emerges here. The employer admits to breaking the rules, and medical professionals confirm the harm. Yet, contract law historically resists forcing the breaching party to pay for this specific type of psychological injury. The definitive ruling that resolves this tension is Elisha v. Vision Australia Limited, 2024, HCA 50. By examining the High Court's logic, we can derive the exact boundaries of liability in modern Australian employment and understand where an employer's financial responsibility legally ends. The baseline rule of contract damages is restorative. If a contract is broken, the law aims to award financial compensation that puts the injured party in the position they would have occupied had the contract been properly performed. However, this liability is not infinite. The primary filter used to limit these damages is a concept known as remoteness. This diagram shows the remoteness logic tree. It illustrates the legal test dictating that a breaching party is only liable for damages that were within the reasonable contemplation of both parties at the exact moment the contract was originally signed. Standard financial losses flow easily down the contemplated branch. If an employer breaches a contract by withholding wages, both parties reasonably contemplated that unpaid wages would cause financial loss. The employer pays compensation. Conversely, unusual or extreme secondary losses are blocked. If a breach causes a chain reaction of highly unlikely events, the resulting damage is pushed down the remote branch, and the court awards zero compensation for those specific losses. Remoteness acts as an objective structural filter. It determines what a breaching party actually pays for, entirely independent of the severity of the plaintiff's suffering. When applying this logic tree to employment contracts, the courts use a specific century-old carve-out known as the Addis Rule, named after a 1909 House of Lords decision. The Addis Rule issues a clear mandate. Damages for injured feelings, distress, or psychiatric harm stemming from the manner of a dismissal are strictly unrecoverable in contract law. The policy reasoning behind this harsh barrier is tied to the nature of the agreement. Employment contracts are inherently terminable. The distress of losing a job is an unavoidable reality baked into the contract itself. Allowing damages for the distress of a dismissal would dismantle the concept of terminable employment. Every firing, no matter how routine, would carry the risk of a multi-million-dollar liability claim for psychological damage. For over 100 years, lower courts and legal scholars have challenged this rigid limitation, seeking ways to compensate employees subjected to particularly brutal terminations. Despite these challenges, Addis remains a nearly impenetrable shield for employers. To win damages for mental harm, plaintiffs are forced to find highly creative legal arguments to bypass it entirely. In the Elisha case, the appellant attempted to bypass the Addis Rule by mapping a specific timeline onto this legal framework. They argued that the events must be separated into two distinct phases. Phase 1 consisted of the flawed, procedurally unfair investigation. Phase 2 was the actual termination of employment that followed. The appellant's primary legal argument relied on severability. They argued that the psychiatric injury stemmed exclusively from the breach in the investigation process, a phase completely separate from the actual dismissal. If the harm came from the investigation and not the firing, they argued the Addis Shield should not apply. The High Court analyzed this attempt to sever the investigation from the termination. The justices found that the disciplinary process and the ultimate dismissal were inextricably linked. The investigation only existed to determine if the employee's tenure should continue. They could not be treated as isolated, separate events. Having unified the events, the High Court then applied the strict remoteness test to the entire matrix of the breach. The court concluded that psychiatric injury was not a reasonably contemplated consequence of breaching the specific procedural clause. Because the flawed process was always leading toward a potential dismissal, an event where distress is expected and uncompensable, the psychological harm fell strictly into the remote category. By ruling this way, the High Court reaffirmed and expanded the Addis Shield. It now explicitly covers the inextricably linked disciplinary processes leading up to a termination, preventing plaintiffs from isolating procedural errors to extract mental harm damages. This split-screen diagram illustrates the macro-level impact of the court's derivation. On the left, we see contract law, where a thick firewall now blocks any path between a breach of process and damages for psychiatric harm. On the right, we see tort law. In torts like negligence, there are existing open pathways to claim damages for psychiatric injury, provided the plaintiff can prove a strict duty of care was breached. Plaintiffs often attempt to use contract law precisely to bypass the difficult evidentiary requirements of tort law. The High Court's ruling reflects an overriding philosophical stance. In contract law, the court prioritizes structural certainty and predictability over compensating an individual's specific harm. The primary goal is ensuring that businesses can accurately calculate the financial risk of a potential breach at the moment a contract is signed. That calculation becomes impossible if subjective, unquantifiable mental harm is allowed into the equation. For human resources and legal professionals managing industrial relations, the Elisha decision provides direct, actionable boundaries. It corrects a common industry misconception, proving that an employer breached an internal HR policy manual does not automatically grant an employee an open checkbook for mental harm damages under contract law. This fundamentally changes how employment contracts and policy manuals should be drafted. The ruling exposes the inherent danger of writing overly prescriptive, highly detailed disciplinary procedures and then strictly incorporating them into the employment contract. The more detailed the binding procedure, the easier it is to accidentally breach, creating unnecessary legal friction, even if mental harm damages are ultimately blocked. The High Court has fortified a boundary established over a century ago. Employers remain obligated to strive for procedural fairness, but contract law dictates that the distress of a flawed exit remains an uncompensatable reality of employment.